So there is this item on page 2 of the Times today, the 24th of November 2020, which is headed, Labour insists Corbyn apologise. And there are a variety of items which we shall be covering. And this is a repeat of the Guardian boast that the Oxford scientists hail their vaccine for all the world. And there is a piece on the page 11, Melbourne's brutal lockdown does job. That is to say that the lockdown is actually seriously stopping the spread of the virus in Australia. And there is a piece about the invention, that is fakery of an expert. Fake expert was invented by a veterinary doctor, this Sue Dyson. And it says, that an internationally renowned equine vet has been accused of making up an expert to authorize her study, which showed that heavy riders are damaging their horses. Sue Dyson faces a disciplinary hearing of the Royal College of Veterinary Surgeons for allegedly forging a letter purporting to come from a government inspector. And this is a piece on page 15 of the Times. Now this one is a tip of the iceberg. I mean, this disciplinary hearing is itself a complete fake event, because the Royal College of Veterinary Surgeons is one of the corrupt outfits that have been allowing mass murders of animals by so-called vets and their associates right across the country. And there is no actual forum for prosecuting these criminals as mass murderers. And the fact that David Penick, who is one of the two QCs appearing in the Supreme Court, allegedly on behalf of Shamima Begum, raises the question as to who is funding this. And if it is being funded by legal aid, so-called, then how much is Penick being paid? Because his daily fees were £20,000 when he was hired by the Manchester City Football Club or Football Association that needed to challenge a European sports body's ban on the Manchester City Football Club. And there is this other cartoon about the Christmas featuring Boris Johnson, and it's a contradictory kind of cartoon. Just like Boris Johnson, it says that open all hours, but the all is crossed out. So shop till you drop. And Hugo Rifkin is writing another piece about the vaccine. And he's saying that vaccine passports are only for Fantasyland. Even COVIDiot libertarians will struggle to make the case that essential freedoms have been destroyed by the pandemic. And Alan Coran's son, Giles Coran, is adding his racist voice to the claim that everyone in Britain is now considered a racist. That is a mockery of all the kind of claims of racism made by victims of racism, attacks and violations and opponents of racism. And this is kind of his following on the story about Ted Hughes being accused of having benefited from slavery. And Melanie Phillips says that COVID cronyism shows state machine is broken. Now, she has only realized this after 50 years. And she's criticizing Boris Johnson making false kind of statement. And there is a big editorial in the Times, headline Great British Breakthrough. It's about the Oxford vaccine. Now the point is that there is no evidence that this thing works or will work. So it's a promotion and marketing of the British kind of thing, that British takeover of the world. I mean, even when Britain is witnessing huge numbers of people dying and getting infected. So we continue with the appearance in Supreme Court by David Pennick and the other QC about Shamima Begum's kind of application to return to the UK to pursue her complaint against the UK Home Office taking away her British citizenship. So there is this long the summary of the Home Office's assessment from 2019 released to the court acknowledged that should Begum become aware of the deprivation of her citizenship decision whilst in Al Hawl, another camp where she was previously held, it is difficult to see how she might effectively exercise her appeal right from that location. And there is a quote, Begum seemingly has no immediate prospect of leaving Al Hawl, traveling to the UK or another location so as to more effectively pursue the appeal. The Panic told the 5 Supreme Court justices that Begum, now 21, needed to be able to participate in the hearing if it was to be conducted fairly. A function of procedural fairness is to uphold the rule of law, he said. It is to ensure that the Home Secretary is applying proper standards that they can stand up to scrutiny. Then he is quoted as saying that the requirements of procedural fairness cannot be overridden by national security without express statutory provision. The court was read extracts of an official report dating back to April 2019, which said that of 900 people who traveled to Syria to take part in the conflict, around 20% had been killed and 40% had returned home. It continued, they have all been investigated and the majority have been assessed to pose no or a low security risk. Panic said, what degree of threat, if any, Ms. Begum will pose on her return needs to be investigated in the circumstances of her case. Sir James E.D., QC for the Home Office, is asking the court to assume the worst when the purpose of the appeal is to determine the facts. Panic added, the court should not assume that Ms. Begum will be in the category of those who pose the most serious threat on her return, or that TPIMS, terrorism prevention and investigation measures, and prosecution would be inadequate to protect this country from her when she returns. Tom Hickman, QC, also representing Begum, said that she was at risk of being transferred to Iraq, where she would face mistreatment or possibly a death penalty. The hearing continues. Now, these are two kind of QCs appearing for Shamima Begum, and what they are quoted in the Guardian report online from the proceedings today in the Supreme Court does not constitute exceptional brilliance or exceptional kind of investigation having been undertaken on behalf of the applicant or on behalf of Shamima Begum for either of the QCs to make that kind of statement that the Guardian has quoted, which means that it is a mystery as to what licensed law traders kind of contribute to the debate or the kind of arguments to justify their being paid £20,000 a day, which is what David Penick has charged the Manchester City Council before. And this also raises the question as to what procedural fairness is pursued by the High Court or the Supreme Court or the court system. Is it only a concept that is recognized when a litigant or a party is represented by a QC? Or is it allowed to apply irrespective of whether the litigant is being represented or they are representing themselves? As has been mentioned in the case of the Russian couple, the Ahmedov and his wife Tatiana Ahmedova, and their son Timur, in the High Court yesterday, in the report about the proceedings in the High Court that were kind of reported yesterday, the access to the evidence contained in the computer device or the disks that Timur Ahmedov has been suspected by his mother to have stolen or hidden. Even if all of that were to be assembled and retrieved, that would constitute less than 1,000th of the evidence that is at the center of the attacks on the Kitten's house in Brick Lane in between July and October 2012. And the other details of the other evidence and other devices that have been involved in the storage that has had to be kind of used over the "33 years since the Royal London Hospital mounted the mass eviction by putting the properties in New Road on auction in 1987. And these evidential items that are original creations, originally researched, originally authored, originally written, originally photographed, originally filmed, originally devised scripts, manuscripts, and documentation. They are, in terms of volume, in terms of number, in terms of the issues and subjects and topics covered, they are several thousand times more than what the Ahmedov and Tatiana Ahmedova and Timur Ahmedov case contains or refers to or is about. So if Tatiana Ahmedova is claiming 450 or £500 million in damages or compensation or whatever, then multiply that by at least 1,500 times and you see what the sum is. Because that is the simplest comparison or comparable kind of damages or amount involved in the items targeted by the criminals in their attack on the Kitten's house in Brick Lane. So the criminals that conspired together and to mount and effect the attacks on the Kitten's house included at various levels and in various details, included the criminals, Mike Tyrrell of the Tower Hamlets Community Housing, Steve Hill, the benefits manager in Tower Hamlets Council, Spitalfields Housing Association ex-employee criminal who became executive employee in the Spitalfields Small Business Association and the criminals involved in the Small Business Association. And previous to that, the criminal, Paul Varma, and of course the criminals in the Royal London Hospital. And the criminals, the district judge criminal called Henrietta Manners, and the deputy district judge criminal, Judith Goodman, and the criminal licensed law trader, Edward Fitzpatrick, and the criminal solicitor, Lucy Green. And other criminals, including the racist criminal employed at the time at the Tower Hamlets so-called law center. All these criminals conspired separately or individually to cause harm, loss, damage, and to perpetrate theft and hiding and concealment and interference with intellectual properties and so on. Now, in order to stop this, prevent this happening, the author and the claimant instructed a licensed law trading solicitor. And that licensed law trading solicitor behaved criminally, irresponsibly, dishonestly, corruptly, and all of these crimes have been kind of documented in detail. So when David Penick's rationale is actually compared with the rationale applying to the claimant against these criminals, as set out in the three claims filed in the Queen's Bench Division during 2013, 2014, 2015, 2016, the evidence and the rationale were again, in terms of the amount and in terms of the kind of depth and the strength of the evidence, were several thousand times more powerful. So what happened to these claims in the High Court in the Queen's Bench Division?